NACDL is the association of the nation's criminal defense bar.
So I'm going to talk, I use this term E-carceration to talk about all the technologies that deprive people of their liberty. Most of the work that I've done has been on electronic monitoring, so I'll focus mostly on that today, but I want to make sure we connect the dots between that and all the technologies that people have been talking about up to now in the conference. Pretty amazing stuff, really. The best example of E-carceration, the classic, is GPS with house arrest. That's what I experienced for a year, and that's what kind of sparked me to do research on this and to keep doing research on it and do campaigns on it. So I want to talk about how I see how I frame electronic monitoring. I don't see it as an alternative to incarceration. I see it as a form of incarceration. It's an alternative form of incarceration, and I think it's useful for us to think of it in that way. And it's a targeted punishment, not a condition of supervised release or parole or whatever situation a person finds them in. And it's part of a surveillance state and part of a surveillance and punishment history. So it's not just a policy, but it rather connects up to a whole history of surveillance, and it's targeted at disproportionately at black and brown populations, LGBTQ plus populations, marginalized sectors, what I call the criminalized sector of the working class. And so it's not a mistake that when I interview black people who are on a monitor, they start talking about slave ships and slave shackles. It really has a historical resonance. So I'm going to make 5 key points that inform sort of how I look at electronic monitoring. The first is that it's an opaque technology. We have very, very little data on electronic monitoring. There's no national database that tells us even how many people are on electronic monitors. We have a few jurisdictions that keep those records, but unlike prisons and jails and probation and parole, we have no global figures. We have no evidence that it works. If you do the research on this, if you look at all the programs of so-called programs of electronic monitoring that exist, you find that these local jurisdictions, the thousands of local jurisdictions that have electronic monitoring programs, don't write reports, they don't do assessments, they don't do evaluations, and they're not called upon to do so by the government authorities that contract them. So we have no information. And the little information that we do have is very contradictory in terms of things that electronic monitors are supposed to do, like reduce failure to appear in pretrial settings or reduce recidivism. So it's a targeted technology, as I've mentioned. Disproportionately, it's part of the structural racism that underpins mass incarceration. So we need to make sure that we connect it up with that, and it does physical and mental harm. And you'll see here a picture that I got sent by someone who was on an electronic monitor, and this is what his leg looked like. And he took his leg into court and asked, "Can I please be let off this monitor?" And they put the monitor on the other leg, and so the other leg ended up looking just like this one. But there's been no serious research done on what is the impact of this device, physical or psychological. We have a lot of evidence, which some people call anecdotal. I consider it to be experiential evidence of people having all kinds of trauma related to being locked into their house for months on end, to being scared when they go out that they're somehow going to inadvertently violate the rules of electronic monitoring, that the rules themselves are so draconian that it's sometimes even difficult for people to figure out whether they're doing the right thing or not. And it creates trauma for people who are living with those who are on electronic monitor. I know that for my own family, for example, every time we went out, they were constantly saying, "Isn't it time to go? You better go home now. We got to get home. We only got 7 minutes before your movement time is up." So there's a whole set of harms that are not researched. It seems unbelievable that this technology has been around since the early 1980s, and we haven't seen any research done on the physical harm of it, let alone the psychological harm. And lastly, I don't think I need to say much about this because all the speakers that have come before me have shown how inaccurate these tracking technologies are. And if Google is giving 68%, what are we getting from these electronic monitoring companies, which are ma and pa shops, or which don't even bother to respond to the hundreds of alarms that they get that people have violated the rules of their electronic monitor? So I want to just put that as a background, and then I want to look at a little bit at what's happening in the world of electronic monitoring at the moment. There's an incredible increase in usage in pretrial and immigration settings for electronic monitoring. There's an increased diversity of devices and data that's captured. There's an increase of what I call free market principles, and there's increasingly an element in pretrial reform legislation at the state level. And there's increased resistance to this technology as well. So I'm going to look at these in a little bit of detail. First of all, once again, we don't have great data, but the places where we have data, some of it is shocking. Harris County, Texas, 27 people on pretrial electronic monitoring in 2019, over 4,000 today. Some of that is as a result of the pandemic, but the jail population in Harris County is bigger now than it was before the pandemic. So this is what we call net widening. Cook County, Illinois has also seen similar expansion, and Alicia Virani, who has done a great report on electronic monitoring in Los Angeles, showing that it's increased by 5,000% in usage in pretrial. In the past, it should be 6 years, not 5 years. Sorry about that. In immigration, we find that the figures are really staggering in terms of, in 2019, we had 58,741 people on electronic monitoring who are under ICE's authority. In February of this year, it was up to 155,000. And one of the things that's important about this is that they're leaving the traditional ankle, and I prefer to call it a shackle rather than a bracelet, because it's not jewelry after all. They've moved from 11,000 on BI SmartLink, which is a phone app, to 126,000, and Joe Biden has said he's targeting to have something like 400,000 people under ICE on BI SmartLink. So BI SmartLink is the device at the far left and the far right. It's a cell phone app. BI, the company that makes it, the country's biggest EM producer and a subsidiary of the world's largest private prison operator, the Geo Group, has its own device that you can use if you don't have a cell phone. But this uses facial recognition and voice recognition for log on. It can collect some biometrics, and likely its capacity is going to increase. The second from the right there is a wrist monitor that they're now using in jails. And they're making people check in different points of the jail as a way of tracking them, and they claim that it saves work for the guards. So I'm not sure why they need to be tracking people in these jails that have sometimes as few as 50 or 75 people in them, but there's an infatuation with this technology. There's the increased data reach, and I think this is crucial, and I'll come back to that, but it's the commodification of the data that's gathered by GPS, the location tracking, that is connected with major data brokers. Thomson Reuters, LexisNexis operate with, and I'm sorry, I did correct the spelling of LexisNexis, but I see it didn't save in the version, so I apologize if there's anyone here who has a very, very high regard for LexisNexis. They're gathering this data, and there's about 900 databases that ICE uses to track the location of people, to track all kinds of data on them. And then companies like Palantir produce algorithms based on that data, and these things can either be can be predictive, or they can also be they can also be used commercially. We have no idea where this data actually is or what's happening with it. It's stored on the clouds. The cloud, Microsoft, AWS, and so forth, but there's little accountability for this data at the local level or the national level. When I'm saying free market principles, I'm saying that it's shifted a lot to user pays. Fees can be $5, $10, $15. The highest fee I've run across is $47 a day in Sacramento, California. But 20 and 25 is not atypical. That comes out to $600, $750 a month. And the majority of people who are on electronic monitors are not wealthy. And this is a healthy chunk out of their income. And in some places they're threatened with reincarceration if they don't pay the fees. So these are some of the big players in this free market. Track, Supercom, satellite tracking of people, also called STOP, which is a subsidiary of Securus, that is a big prison phone and prison video visit technology provider. Sentinel, Supercom, and then of course there's BI there that says, in their ads they say, join a community that cares. Okay, so this is, so the other part of free market principles is that the way the contracts are being negotiated. As I said, every jurisdiction has its own contract for electronic monitoring, but historically most jurisdictions would contract with one provider, but now we're seeing that they're creating a list of preferred providers, and there's already been some cases where there's some under-the-table kind of operations going in terms of who's getting us, which company is being chosen by the by a judge or by a sheriff. A case in Louisiana, Judge Paul Bolin was prosecuted because he was assigning people in his court to ETOH, which was an electronic monitoring company that was owned by one of his major campaign contributors. So there's a whole nexus of potential for corruption. Some of this is happening in other parts in Louisiana as well. So what I'm really about in this work is challenging e-carceration, is really changing the narrative and finding ways we can intervene to reduce the harm or reduce the actual usage of these things. So I'm going to talk a little bit about some of the things that I think where lawyers could be involved. It might not be always in the exact courtroom setting, but there's legislation, there's litigation, and so forth, where electronic monitoring has come into play or where there's potential for it to come into play. So I'm going to start with, we've been doing a lot of who knows, who's got their this and who's got their that. How many people know who Amilcar Cabral is? Anybody? All right. So Amilcar Cabral is an African revolutionary, and he made a famous statement that's called, "Tell no lies, claim no easy victories." So I'm saying that getting people out of jail on an electronic monitor is kind of an easy victory. It may be difficult at times, but what I'm arguing is we shouldn't be satisfied getting people out on electronic monitors, and if we do, we should be very conscious of the fact of what the conditions of that monitor are. Because if you're on 24/7 house arrest with a monitor and you're waiting a year or 2 years before your case comes to court, your life is wrecked. Right? You can't earn any money if you're living by yourself. You can't go shopping. There's a whole range of ways in which this creates serious problems for individuals who are on monitors, particularly in a pretrial setting. So we established a document in 2017 called Guidelines for Respecting the Rights of People on Electronic Monitors. So you might want to have a look at that, to look at some of the things you would be conscious of if you have a client that's going to be put on an electronic monitor. It's not just that they get out of jail, and I'm certainly not saying that they should stay in jail, but we should also recognize that when they come out of jail, they're subject to a different form of incarceration that can also be very punitive. The second one is, live, laugh, litigate, right? So there's all kinds of possibilities for litigation with electronic monitoring. I mean, there was one case, it didn't succeed, but there was an attempt to show that charging somebody $25 a day for electronic monitoring was cruel and unusual punishment, and basically it meant that the person who was the sole provider for 3 children wasn't able to maintain their apartment, had to sell their car, had to farm their children out to other relatives because they weren't able to afford the fees for electronic monitoring. So the case was made that this amounted to a form of cruel and unusual punishment. In 11 states, we have lifetime GPS for people with certain categories of sex offenses. So lifetime GPS is extremely punitive, and the conditions of this they vary, but I've been working with someone in Illinois who's on lifetime GPS, and he was in a relationship with a woman. They were going to get married and have children, and the conditions of his lifetime monitoring said that if they had children, he wouldn't be able to associate with them. So there's a whole degree of arbitrariness about regulations on electronic monitoring in general, but when it's lifetime GPS, it can be even more problematic. And then there's this whole question of tampering with the devices. Tampering, trying to remove the devices. I mean, we just had a man from Effingham, Illinois, go to state prison for 2 years because a battery on his device kept dying, right? Now, maybe he wasn't charging it. Is there anybody here who's never had their cell phone battery die? Because that's what an electronic monitor is like. The battery, you have to plug it in, and then as it gets older, the lifetime of the battery becomes shorter and shorter, and it becomes more and more problematic. So we have people that show up at McDonald's to charge their electronic monitors, but if it goes dead, they can be charged with tampering, which in many states is a felony. In Georgia, you can do 7 years for tampering or removing your electronic monitoring device. So I think we need some litigation on that particular piece. There's also the question of pretrial justice reform and how electronic monitoring weaves into this legislation. So in Illinois, the advocates, many of whom were lawyers, there was a statewide coalition to end money bond and to pass the PreTrial Fairness Act. But there was a deep consciousness driven by the experience of people who had been on the monitor and who had been advocates for people on the monitor. There was a deep consciousness that they wanted to minimize the extent to which, even if they got rid of cash bond or cash bail, that it wouldn't just mean that they could put thousands of people on electronic monitors and put them and subject them to 24/7 house arrest, which is exactly what the sheriff in Cook County, Sheriff Tom Dart, was doing in all too many cases. So they tried to fight to reduce the imprint of electronic monitoring. They weren't able to get it totally written out of the law, but they were able to at least insert some due process clauses that weren't there before. So now in Illinois, you have to, if a person's going to be put on an electronic monitor, pre-trial, they have to have a full hearing just like they would for any sentencing procedure. And if they're going to be kept on it for more than 60 days, they're entitled to another hearing. Now, I'm going to come back to that in a second, but in New York, they weren't able to secure anything like that, but what they did is in the PreTrial Reform Act, they inserted a clause that said no county or state authority could contract with a private provider to do electronic monitoring. So essentially, that got rid of electronic monitoring because it's only private providers that have this technology and contract for it. So I'm just saying that there's ways to work around some of the legislation, but what we're seeing in Illinois right now is pushback. So we're finding some of the judges are refusing to give people what the law entitles them to, because the Illinois Pretrial Fairness Act, also entitles people to have 2 days a week of movement for 8 hours. And that's basically to enable them to do the basic necessities of life, whether that's shopping, whether that's laundry, whether that's getting the car fixed, whether that has to do with caregiving responsibilities. That's in the law. But some judges are saying, we're not going to do that. So they're sentencing people to 24/7 house arrest, flying in the face of the law. So there's a whole big battle going on right now between the sheriff, who in this instance is saying he's following the law, and the judge who's saying he's not, and the person who's on the monitor is caught in between. So these are places where legal intervention is required. I mean, there's a whole team of public defenders and their allies in Cook County that are engaged on this very issue, trying to make sure that the gains that have been won in the Pretrial Fairness Act are not wiped out by counter moves from the state or from judges. I mean, we had a similar case in Illinois in 2019. We succeeded in getting the Department of Corrections to agree to file an annual report of how many people they put on electronic monitors, how many people were sent back to prison for violating the rules of the electronic monitor, and so forth. And although it was passed into law, they still haven't produced a report. And we haven't been able to hold them accountable. Fortunately, in the meantime, the Department of Corrections decided not to put people on electronic monitoring, which I'm sure was a lot because of the pressure that they faced, but it just shows that some of these, that the laws, even when they're passed, need to be observed, and we need to follow up on them to make sure they're enforced, as I'm sure you're well aware of how the letter of the law is not always what happens in practice. There's been a lot of talk already here about the privacy concerns. I mean, warrantless electronic searches. Basically, an electronic monitor is a 24/7 warrantless electronic search, right? I mean, they're gathering all this data from you, and the more capacity the devices gain, the more those searches are going to yield. There's also some freedom of speech and freedom of association issues. Prakash Shurman, a young man in New York who was convicted of a murder when he was 15, did 6 years in prison and got the conviction overturned. He's now he's been over a year on 24/7 house arrest, awaiting retrial. So basically, he's been a very, very outspoken critic of the criminal legal system, and he's paying for that. Michael Cohen, as I'm sure people are aware, tried to write a book when he was on electronic monitoring, and that created a whole issue about whether or not someone was entitled to do that while they're on pretrial release. I think also it's interesting to consider the ways in which electronic monitors contribute to a denial of due process. Almost similar to what happens when people are in pretrial detention. That is, if people are on an electronic monitor for a year or 2 years and they're paying monthly fees, eventually it becomes unaffordable, and they just kind of throw up their hands and say, well, give me the deal. I'll take the deal. We had a well-known case of that here in Illinois of Lavette Mays, who was on a monitor for about 4 months, but she had 3 kids. She couldn't carry out her caregiving responsibilities, so she just threw up her hands and said, give me the deal. And the flip side of that as well is that you don't have access to income, so you can't support your family, even if it's not about being able to do caregiving. So there's a whole set of ways in which the monitor curtails people's freedom and pushes them in the direction of taking a deal the same thing that happens to people who are incarcerated and they just get tired of waiting it out. So I think that's something to consider. I mean, I also had one person I was working with in Chicago who was trying to get some movement, and her lawyer was charging her $250 to write a motion. This is an unemployed woman, mother of 3 kids, who's been on an electronic monitor for about 17 months and has lost about 4 jobs because because the sheriff wouldn't give her movement to go to work. So I'm just saying there's a whole set of things around due process here that put incredible pressure on people. I'm just putting this in there. Free all political prisoners. I'm saying Mohawk Johnson, who's a man in Chicago here, who's been on a monitor for about a year and a half. He's on Twitter. I don't know if has anybody ever seen Mohawk Johnson on Twitter? Okay, there you go. Okay, Mohawk Johnson has been on. He was a BLM, a Black Lives Matter activist. He got arrested in September of 2021. He's been on a monitor 24/7 ever since. He's recorded on his Twitter feeds. He's posted over 60 calls from the sheriff saying that he's left his house without authorization. And in each one of those calls, he's got a video of himself in his house, in his bed, watching TV, following the rules, and he's fighting with these people. And as he points out, in most cases, I mean, in one of the cases, they showed up and handcuffed him in his house while they searched his house. But as he's saying that even if he doesn't get violated, these are all getting in his court record. So when he goes in for sentencing, he's got 60 violations of his electronic monitoring rules, all of which were false, but nonetheless, they're there. I mentioned Prakash, and I think probably some of you have heard of Stephen Donziger, defense lawyer in New York, who spent 993 days on an electronic monitor for a misdemeanor awaiting a decision. So, I mean, it's a technology that can be used to punish in a very targeted way as well. So, I think a last place where we might want to look at is in the federal system. They've released about 30,000 people on home confinement. Most of them are being made to finish their sentences, and many are going to be sent back to prison. So that's a whole other struggle to fight. So I just want to say that there's cases where people are fighting the EM companies. There was one EM company that didn't respond to alarms for one of their clients, and this guy ended up committing a murder. And so this is in Louisiana. So now the local authority is charging the company with in the murder. I can't remember if it's a homicide charge, but it's definitely a serious charge. And the last thing I want to talk about is who owns the data, right? For me, this is actually the biggest issue right here. And as people have been talking about before, who owns this data and what happens to it? And this isn't just about electronic monitoring. This is about all these technologies and who owns this technology. It's big data companies, Amazon, Microsoft, IBM. These are the companies that control the data for everyone, and then they're doing deals with LexisNexis and Thomson Reuters and Palantir to find ways to make more money out of this and also impose more controls on people as they gather more and more data. So, and I totally support these 34-digit alphanumeric codes, but we need to do a little bit more than this. We need to actually target some of these companies along with the local and state authorities that work with them to implement these electronic monitoring programs and try to curtail this rather than allow it to keep spreading. And with that, I'll yield to Alicia, and thank you very much.